Good morning, Mr. Weird.
Good morning, Justice Marshall. May it please the Court, Les Reardon. I represent Gail Rosalind Johnson. In terms of the facts of this case, we're here on a misuse of client funds case. And let me go right to the facts. And we've conceded by stipulation these facts, and we also concede objectively they're very disturbing. And this presents a difficult case for my client. My client misused, appropriated for herself $28,000 from a gentleman named Ward, who at the time was a fiduciary for her child. Subsequent to that, and that is in February of 2004, subsequent to that, in June of 2004, my client used the funds of an elderly woman to pay back Mr. Ward. In August of the following year, my client used the funds from a closing of a woman to use to pay back Mrs. Marinella and also to use those funds. There's entire commingling of the funds during the entire period, so it's not just in these instances. And then in addition to that, when my client was called in front of bar counsel, she did not objectively testify correctly. And I would concede my client's testimony, I think, misled bar counsel to some extent.
Mr. Riordan, when was the accident where she broke her, smashed her leg?
The accident was in June 2003, Justice Botsford. It was, 8-10 months prior to the first violation. And I'm going to go through some of the facts on mitigation and try to show you where we are relative to that. But I want you to recognize up front that we recognize that this is some of the most serious conduct that you have to deal with. And I think from reading your case is something that you take a hard line and should. I hope that I can show you in the context of mitigation that you can take a hard line. You can protect the public, and in doing so, that you can take the right approach regarding attorneys who face these types of challenges. In any event, as I said, in June 2003, Attorney Johnson suffered a fall while boarding a gambling boat. Now, before I go into the series of facts, and I think this is absolutely clear from the record, Attorney Johnson, for her entire life, has been burdened by a series of what I consider some of the most debilitating psychological problems. So much so that the master in this case and the board stated, and I would suggest that this is a matter of finding, that she can't get back in unless she proves she overcomes her psychological problems. And those psychological problems are depression, chronic depression. She has compulsive disorder. She's a reformed alcoholic. She has, I think, since giving up alcohol, has been a compulsive gambler. And I don't think there's any dispute about those issues. And I don't think there's any dispute that she has sought treatment for those issues, that she did so successfully with the alcohol, that she did so with the assistance of bar counsel relative to the gambling, and saw the same psychologist for almost a decade. In fact, the psychologist that she did speak with and that she did receive her treatment from is the one who testified here. In any event, she's barely held it together, and yet she has maintained a very vibrant and successful practice. She has a lot of the factors, the honorable factors that we call typical mitigation: service to the bar, teaching experience. She has served her clients well and creatively, and she's barely held it together, but she's done it. So in June 2003, she breaks her leg, and it's a significant break. She has a bone cadaver graft. She's in the hospital for the better part of 6 weeks. In August of 2003, just as she's getting out of the hospital, she's facing foreclosure on her house. She doesn't take her client's funds. She borrows money. She goes home, and she's in the kitchen of her house, which is her law office, in a hospital bed. She eats in her hospital bed. She sees clients in her hospital bed. She conducts business in her hospital bed. She's in terrible circumstances. In the February of 2003, she was diagnosed with lymphoma. She received a biopsy just right after this accident. She has cancer. Her
2004?
2003. 2003. She had her biopsy in September of 2003. Justice Cordy.
Okay.
She has a mother who is in her 90s who is disabled. In fact, I think it's relatively clear that the mother was to be taken from the home just about the time that she went in for her second operation and committed her first series of violations. I don't think anybody would dispute that this woman, between the period of June 2003 and February of 2004, was overcome with an avalanche of personal difficulties, and I think all of us would recognize that if we were confronted with those difficulties, there would at least be some stress. I think what's appropriate to do when you have a situation like this is move towards what is the impact of that stress in terms of intentional misconduct. And it's a very difficult question that you have to confront legally, because these are bad cases, and you have a policy to protect the public, and yet it's all tied together.
I don't think intentional misconduct is necessarily the touchstone, because when you're protecting the public, if it's somebody is out of control for whatever reason, we may still need to protect the public.
Absolutely. I think you absolutely need to protect them, but you follow policy, I think, that requires people who get in these situations to conceal. You follow a policy that has attorneys constantly covering up this type of activity, and I think you have it here. And let me point out, the master or the hearing officer in this case rejected a psychologist's testimony that Attorney Johnson was in a fugue state, or what he called a dissociative state in February. We had eyewitness testimony that described her as in excruciating pain, in fog, in a deep depression, acting crazy and unable to think things through at the time right before she went into the hospital. The psychologist testified she was in what he called a fugue state then, but when he asked about the future misconduct, he said she was irrational, but she knew what she was doing. Everything had gone to pot by this time. She went in and testified, I think, inappropriately in front of bar counsel. But she's facing at this point.
Was this the person, the psychologist who testified, the person who had treated her?
Yes, who had treated her and who was referred by bar counsel.
And was she the respondent totally forthcoming to the therapist about the misuse of funds and so on?
I don't think so. I don't think Attorney Johnson was forthcoming with anybody, even those people closest to her and who would help her the most during this period of time.
The hearing officer found that the respondent was less than candid with her therapist concerning her serial and systematic misuse of clients' funds for personal uses.
I agree. That's, as I said, I think Attorney Johnson was very isolated. But you know, to just reject his testimony, I mean, to say that a psychologist can't assess, what his patient is telling him. I mean, they deal with irrationality. They deal often with untruth. But I think more to the point.
Excuse me, was she less than forthcoming about anything other than the
Oh, sure.
details of misconduct?
She called Dr. Levinson from Mohegan Sun. He's treating her from gambling, and he saw it on the ID, the phone ID. And Dr. Levinson said, "Well, Attorney Johnson, where are you?" And she gave him some off-the-cuff answer. She was clearly at the casino. Now, this isn't during the period where this is a problem, and I'd like you to recognize that at least. Attorney Johnson's problems with gambling, though they've been lifelong, were in a period prior to June 2003, and then there appeared to be a relapse in 2005 after this matter had come up in front of him.
Mr. Leardon, let me ask you this. What you're asking for is a suspension of 24 to 30 months, and then you're asking for, that she be permitted to practice law under very stringent conditions.
Sure.
We have close to 50,000 attorneys in this Commonwealth.
I understand.
And a lot of them are alcohol addicted, gambling addicted, psychological problems, health problems. It may not seem obvious to you, but to ask for...
Obvious to me, Your Honor. It's a tremendous administrative challenge for you, okay? And you have to decide, but you have to recognize the causal connection between these attorneys and their public and taking care of them. I don't know how you address it administratively, but you can impose conditions, and you can still recognize mitigation. The reason the time is suggested is because of the Guidry case, and I really haven't had an opportunity to discuss that. But Mr. Guidry, who was a wonderful man and I spoke to personally, was not confronted with within this period of time with those kind of challenges, and his behavior was intentional. I think you need to, and I hope you try to grapple with, how do we deal with these people who are confronted with this, and how do we save bar counsel from the problem of dealing with every person who says it's depression? I think you need to do something proactive here. But in any event, if you honor your law, you have to honor at least that this is special mitigation. And if it is special mitigation, which I suggest it is, then you have to address causal, and your cases don't address what is causal, except Guidry and except Johnson, which are timing factors. I think you can do something good for the bar and still be hard line with Attorney Johnson by acknowledging her mitigation. What you do in terms of suspension, as long as you honor the mitigation, is within your deference.
Thank you, Mr.
Thank you.
Reardon. Ms. Vecchione?
May it please the Court, I'm Constance Vecchione, representing Bar Counsel. The respondent, as you've heard, raises a single issue on appeal, whether the single justice was in error in indefinitely suspending her, given the circumstances that she claims as mitigation, and her further claim that, contrary to the explicit findings by the hearing officer and the board, her claim that these events were causally related to the misconduct. As Mr. Reardon has acknowledged, the Board of Bar Overseers, the hearing officer and the Board of Bar Overseers made findings that the medical and psychological problems raised by the respondent as claims in mitigation were not causally related to her serial misappropriation of trust funds from the 3 separate clients. And as I think you understand, but perhaps wasn't clear from the recitation of facts, the amount misappropriated increased over those 7 months from the $28,000 that she initially took in February to forestall a foreclosure to over $65,000 by the time the misconduct ceased, and that the last 2, the money was taken from the last 2 clients only after the initial complaint was filed with Bar Counsel by the first client. So that while she was being investigated, she continued to take money from the second and third clients. In adopting the findings and conclusions of the special hearing officer rejecting the claims of mitigation, the board determined that the respondent's longstanding financial problems and the underlying gambling addiction were the true cause of the misconduct. All these findings are well supported by the evidence, and this court has held in matter of John Johnson that financial problems do not justify abdication of professional responsibility. The board, the hearing officer, found that the respondent was not, as she claimed, in a fugue state or otherwise irrational during the months at issue. This was well supported by subsidiary findings that the misuse was systematic and calculated, that she demonstrated awareness of each client's funds as she misappropriated them, that she did handle certain client matters during these months, that she represented herself in court on another matter, that during this time frame she prepared detailed itemized bills for 2 of these 3 clients. These were bills that were itemized as to dates, service rendered, and time spent, that she wrote a detailed professional letter to Bar Counsel in response to the initial complaint, setting out the whole history of the representation of that client, and that she did not report that the psychologist who did not see her during this time period testified as to what he considered to be her irrational state, but she was in fact being treated by many doctors during this time period, obviously. All those medical records were in evidence. She put them in evidence herself. And she did not report depression or confusion to any of those medical providers during this period, and none of them made note in the treatment records of any such concerns. Obviously, these are credibility findings, which are the sole province of the hearing officer, and were adopted by the board. There was substantial evidence, for the single justice thus to enter the to agree with the board and to enter the order of indefinite suspension. So we're thus brought to what I think is the core of the respondent's argument in her brief, and what I think Attorney Reardon is attempting to say here. And this is the method by which she attempts to go around the obstacle of the credibility findings by the hearing officer and the board, and that is her contention that the hearing officer, as a matter of law, was required to find that her mitigation was causally related to the misconduct. What she says in her brief is that special mitigation factors of the type present here, when they arise just before the misconduct, are causal by their very nature. And for that, this, she says, is the holding of this court's decision in matter of John Johnson in 2005. Bar counsel's position is that this is a misreading of the John Johnson case. I mean, there the court did indicate that a circumstance that arose after the misconduct. In Johnson, it was the tragic death of a family member, by definition could not be mitigating, by definition could not be causally related if it only occurred after the misconduct. The court was not suggesting then that misconduct that occurs before or contemporaneous, that claims of mitigation that occur before or contemporaneously with the misconduct, are necessarily going to be found to be mitigating. There still has to be that finding of a causal relationship that there was not here. And looking at Johnson, you'll note that not only did in addition to saying that, yes, the death that occurred after the misconduct could not be mitigating, the court also looked at his alcohol consumption and said, okay, yes, there was evidence that his alcohol consumption had increased prior to the misconduct, but there was no evidence that that was causally related to the misconduct. And this issue with alcohol has come up in several other cases. In Johnson, the courts cited to Luongo. There have been single justice decisions, matter of Gustafson, where the court has repeatedly said, yes, yes, he was drinking, yes, there was alcoholism or an alcohol problem, but there's no showing that that was the cause of the misappropriation. And that is what we have here. Yes, there was illness. Yes, there was the fractured tibia. The hearing officer, the sole judge of credibility, rejected the findings, rejected the claim that those were causally related to the misconduct. The respondent in her brief goes to great length to compare her claim in mitigation favorably to the only two cases of which Bar Counsel is aware in which special mitigation has been found in matters involving intentional misappropriation of funds, and that's matter of Dodd and also matter of Guidry. In the Dodd case from 2005, where there was very good decisions by both the board and the single justice. In Dodd, 180 degrees opposite from the findings in this case, the board expressly credited that the respondents, that the lawyer's congestive heart failure impaired his judgment and impaired his cognitive function. So there was an express finding of a causal relationship in Dodd. In Guidry, which was a 1999 case, a stipulation for a 30-month suspension for misappropriation of $4,000 in an estate matter. Guidry was also the subject of discussion in the matter of John Johnson case, and there too the court in the John Johnson decision distinguished John Johnson's misconduct from that in Guidry. In Guidry, unlike John Johnson and unlike this case, there was a finding that an extreme family crisis caused the financial and emotional stress that led to the misappropriation. By contrast, and again, in this case, the hearing officer and the board specifically rejected the contention that her claims that her personal and medical issues caused the misconduct, finding instead that the problem was the financial problems and the underlying gambling addiction. There's also the distinction in Guidry that, and this court made this point in John Johnson, that in Guidry he repaid the money, Mr. Guidry did, prior to any complaint being filed with Bar Counsel. That point was made by the hearing officer in this case because it was emphasized by this court in the John Johnson case. In this case, obviously, not only did the respondent not repay the money before the complaint was filed with Bar Counsel, but she continued to misappropriate funds in 2 additional instances after the complaint was filed with Bar Counsel and lied to Bar Counsel about what had occurred. It's well established that the general standard of review when a disciplinary decision is imposed by a single justice is challenged is whether it's markedly disparate. The court only looks to whether it's supported by sufficient evidence, constitutes an abuse of discretion, and is free from error of law. Here, the decision of the single justice upholding the board's decision to adopt the credibility findings of the hearing officer and the findings on the lack of a causal relation. This was all fully supported by the evidence, and given that fact, as the respondent, I believe, concedes, the imposition of an indefinite suspension is consistent with judgments in comparable cases and with the law in matter of chauffeur and other cases such as matter of Bryan that suggests that indefinite suspension or disbarment is the standard sanction
Ms. Vecchione,
in
can I
such
just
matters.
ask you one question? At the time of the hearing, was there evidence as to whether her gambling addiction was continuing?
There was evidence, and it was.
Okay. Thank you, Ms. Vecchione.